Now let us finish up this chapter by looking at the end of chapter questions and how we should approach these questions. Right. First question reads, who is a promoter? The question is basically open-ended, so it means that we can choose any definition. They don't say that who is a promoter according to Tychus versus the grant, no. But who is a promoter? So you'd rather just highlight the simple one, right? Is a person, right? Is a person that forms the company and performs or tasks to get the company started. Has to do with that part, right? That part. That's who a promoter is. Explain the significance of a promoter in forming a company, right? How significant is this person, right? Significance. Right? How important is he, right? So he's the one that basically, he's the one that forms the company or conceives the company, forms the company, right? Then we also have we know that performs or tasks, just basically coming up from the question, right? From the definition, performs or task to get business started. So probably those are the significant why promoter is important, right? Right? He conceives the business, basically. He is basically the one behind the idea, right? Then he also does everything to make sure that the company starts. Mention 4 activities that the promoter has to undertake in the course of establishing the company, right? What can he do? What does he do, right? Activities. So the activities that he can do, we know he basically forms the company and his business. He can appoint directors of the company. He incurs preliminary expenses of the company, can enter into transactions on behalf of the company, right? The particularly said that 4, but you know there are a number of things that you can actually include there, right? So it's short and concise and you move on. What does a promoter or the company, right? So the promoter owes a fiduciary duty to the company, right? Or a duty of trust, a duty of trust. That's what he owes, right? He owes a duty of trust. They're saying that in the case of Elanga and New Sembroni Phosphate, right, holds that promoter of a company stands undoubtedly in a fiduciary position. mention any two consequences of this fiduciary relationship in dealing between the company and the promoter. Right? What are the consequences, right, of this fiduciary duty? Two consequences. The first is basically that promoter is prohibited from making secret profits. Promoter is prohibited from making secret profits. And the other one is that promoter should disclose all profits made to an independent board. Board or shareholders. So he is required to disclose all profits made to an independent board or shareholders, and he is prohibited from making any secret profits, right? Any secret profits. So that's basically it. What remedies do members have against promoter who breach the duty during cooperation? So the remedies that are there, right, for the breach of this duty, there are three. He can be sued for damages, right? We saw what case was there is it Tycross, right? This grant. Then you can terminate or rescind contract, right? Then, or you can compel him to account. So these are the three, right? Compel him to account, rescind contract, and or sue him. Those are the remedies that exist for the breach of duty of trust, right? Number 8, who is liable to pay for price of goods bought by the promoter on behalf of the company once the company is incorporated? So for that one, we know those are pre-contracts, right? Pre-incorporation contracts. So we would say that once a company is incorporated and has adopted or rectified the contracts, adopted the contracts, then the company is liable. Otherwise, the promoter will be liable if the company doesn't adopt the contracts. So we're saying that once a company is incorporated and has adopted the contracts, then the company is liable. Otherwise, the promoter will be liable if company does not adopt these contracts. That's basically it. That's number 8. Number 9, discuss the legal position regarding the effect of incorporation contracts to a company after incorporation. So we could start with the definition of what are pre-incorporated contracts. So pre-incorporation contracts are contracts entered by promoter on behalf of a company not yet formed. Those are incorporated contracts. So the rule there is basically is that promoter cannot be an agent of a company not yet formed, right? Hence, he is personally liable. But if after incorporation, the company adopts the contracts, then the liability shifts to the company. That's how you're supposed to write a particular question like this one. We're saying that what is the incorporation contracts? We're saying that the incorporation contracts are contracts entered by the promoter on behalf of a company not yet formed. Then we're saying the promoter cannot be an agent of a company not yet be formed. Hence, he is personally liable, right? But if after incorporation, the company adopts the contract, then the liability shifts to the company. That's to do with incorporation, pre-incorporations, right? So that's chapter number 9. Let's go to number 10. Explain the relevance of Nali Farm Limited and Kolomani and the Nations Seed Company. So you can see that they have told us the case right here. So definitely want to talk about what are the facts of the case, right? We know the facts of the case, right? And then we talk about how is it relevant. So the facts, we're saying that Kolomani, the promoter of Funali Farm, entered into a contract of sale with the Sidico, right? To buy seeds, right? After incorporation, Nali Farm took over the seeds and farm. Then realized the seeds were affected. Hence, sued the company. So what we're saying here is that this case looks at who was eligible to sue Seed Co. Right? The ruling was that Kolomani was the one to sue Seed Co because Nali Farm Nalifam Limited did not adopt the contracts, adopt the contracts. So we're looking at the facts, right? We're looking at the facts that Koromani, who was a promoter of Nalifam, entered into contracts of sale with Seedco, right? To buy seeds. After incorporation, Nalifam took over the seeds in the farm and realized that the seeds were defective, hence sued the company, right? Sued the company. This case looks at who was eligible to sue Seedco. The ruling was that Koromani was the one to sue Seedco because Nalifam had not adopted the contract yet. That's to do with that particular requirement. All right, now let us look at other question, right? We're looking at question number 10. The question number 11 says, what is meant in company law by the term incorporation? So incorporation is just forming a company that requires a separate legal entity, right? Or a separate legal personality, right? So is forming a company that assumes or takes on a separate legal personality. That's incorporation, right? That's why we cannot say that we are incorporating a sole trader, right? That's not the term that we can use, because we have to make sure that it assumes a separate legal personality. So we form a company, right? So most people I said it in chapter 1 that it's a misconception. Amangona uti tabangaru register company. Koma new sense makhala kuti wapanga register business, maybe sole trader, partnership, right? Because there are a lot of procedures for you to register a company, right? It assumes a separate legal personality. You have to have lawyers, accountants to help you to form this company, right? So it assumes a separate legal personality. So it is forming a business that assumes a separate legal personality, right? Personality. That's what incorporation means. Right. This NF5 content required in the application of incorporation form, right? Incorporation form, right? So content of the incorporation forms content. First tip, full name and address of applicants, of each applicant. Right? That's number 1. Number 2, right? Number 2, we are looking at full name and address of directors and secretary to the company. Right? Address of each director and secretary. We will see secretary, we will secretary to the company, right? I'm at company secretary. This company secretary is a lawyer by nature, right? See secretary made moves out, right? It's a company secretary, and we'll look at it as we proceed through the chapter. Another thing is particulars or details of occupation of business. Occupation of business of the directors. What do the directors do? Are they directors in other companies as well, right? Those are the particulars, right? The registered office of the company. The registered office of the company. The registered office of the company, right? So, and here we've basically talked about, I think, 4, right? 4, right? So you could talk about also declaration, right? Declaration that information is true, correct. Declaration that the information is true and correct. There are a number of things that you can also include, right? But I will stop there. They said 5, then I'll stop there. All right. That's to do with that. Then we should go to what is meant by the statement of capital. All right. What is the statement of capital? Statement of capital, right, is a document. Is a document that is sent to the registrar that includes information about shares that have been subscribed. So includes information about shares that have been subscribed. That means they include things like who are the people that have subscribed, right? For each class, you can talk about what is the power value for those, right? What is the number of shares and so on and so forth, right? That's what the statement of capital is all about. What is the historical relationship between the statement of capital and authorized shares? So we know that prior to this, the Companies Act, so we could say that the current Companies Act, so in the Companies Act, right, CA, right, 1984, right, a company was required to include in the memorandum, right, the authorized share capital, right? This was the maximum or the ceiling, the maximum number of shares that can be issued, right, by the company, right? This was abolished, right? This was abolished with the CA 2013, right? Companies Act 2013, and requires to include information, right? Information of subscribed shares, right? Shares no longer in the memorandum of association, but in this document called statement of capital. So after being dispersed, still there was supposed to be information, including the information, including the shares that have been subscribed on the shares that have been subscribed, but they were included in a separate document called the statement of capital. Right? That's basically to do with the relationship between the authorized shares and the statement of capital. Now let us look at explain the legal effect of the certificate of incorporation. So what is the legal effect? What? So we're saying once this certificate is given out, it means the company is now a corporate body which can do the functions of such an association, right? That is, right? What are the things that he can do, right? We know that he can basically own property in their own name, own property, right? Sue or be sued in his own name, and so on, right? So it assumes a legal personality. That's why it's called a corporate body or a body corporate, right? So it means that the moment that you receive this, right, you are no longer part and parcel of the owners of the company, but you are a separate legal person, right? A separate legal person, and you are a corporate body that can basically do functions as such, right? That is sue and be sued, right, in its own name, assume its own assets, and so on and so forth. That's to do with the legal effect of a certificate of incorporation. Then going to 16, discuss the legal position where a company enters into a contract and it is subsequently discovered that it did not follow certain registration requirements. Is the contract valid? Give a reason to us. So they're saying that you what? You registered a company, right? But subsequently, you identify that there were some defects, right? Things that some irregularities. So they're saying that is the contract that you entered between you and the third party valid, right? So that was to do with the conclusiveness of a certificate of incorporation. So we could say that once a certificate of incorporation is awarded, this is enough evidence that all requirements of incorporation were complied with. Incorporation were complied with, right? So any irregularities that are thereafter found do not make it invalid, right? So any irregularities that may be found, right, will not affect its validity. Affect its validity. Its validity. So say, what's the reason, right? We saw the reason, right? That so once this is because, right? This is because once a company is formed, can enter into contracts, and it would be unfair to the parties in the contract to void the contract on the grounds that there were some irregularities. It will be unfair for any party there. So what we're saying is, right, we're saying that once a certificate of incorporation is awarded, this is enough evidence that all requirements of incorporations were complied with. So any irregularities that may be formed will not affect the validity. Right? This is because once a company is formed, can enter into contracts and would be unfair to the parties in the contracts to void the company or terminate or make it not when you say we're not talk about void, it means that we are saying that the contract is not valid, right? It's not valid. So we're saying that it would be unfair for the parties in the contract to void the contract on the grounds that there were some irregularities, right? Because the people that were going to the contract after seeing the certificate of incorporation, right, assumed that the company had complied with all the regulations and requirement of incorporation. So that's what it means. Right. Discuss how conclusiveness of certificate of incorporation is. Just basically, it's a similar questions, right? Because I've been talking about the conclusiveness of the certificate. We're just saying that what a certificate of incorporation is enough evidence to conclude that all requirements of incorporations were complied with, right? And any irregularities that are found after that cannot invalidate the contracts, right? Or cannot invalidate this incorporation, right? That's basically it, right? That's basically it. What you have to do is just to make sure that you rectify those, but will not affect in any manner the validity of that company. That's to do with conclusiveness of certificate of incorporation. Now let us look at a scenario-based. This is the first time that we are meeting a scenario-based question, right? Question 18. Let's go to the requirements. Advise Mr. Ifisi whether or not the information discovered justified the rescission of the contract. Rescission just coming from the rescind, which means to terminate, right? They're saying that, is it advisable that they can terminate the contract? So they're saying that Union Bus Company, once a successful passenger transport company, is now on the verge of liquidation, mainly due to the stiff competition from the minibus operators. Of immediate concern to UBS is its failure to pay its suppliers, once notably General Tyre Merchant Limited, GTM, whom UBL had contract to supply it with 10 million worth of tires. It is in its present financial position, the only option available to UBC is to have the sale agreement rescinded without attracting a legal suit for loss of business. In their desperate bid to justify the intended rescission of the contract, UBM conducted a search at the Registrar of Companies. To UBC's delight, the search has revealed that while GTM is duly registered company under the number M0922490, some formalities required for registration for a company had not been fulfilled. Mr. Chisi, the managing director of UBC, has approached for your advice, eager to confirm his conviction that although registered, GTM Limited is a illegal company and therefore cannot enforce or in any way sue on the contract. So we can see, I just want to explain the scenario. So you have UBC, a transport company, like so and so on, right? So this company is in financial difficulties, right? Financial difficulties. But their most concern is, their immediate concern is failure to pay their supplier, GTM. So GTM had supplied tires worth 10 million to UBC. So although there are any financial difficulties, their immediate worry is that they would fail to pay this 10 million because they're in financial difficulty. So what they did was to find a way of terminating the contract, but without attracting any legal suit. So in doing so, they tried to find some loopholes. So they went to the registrar to look at their registration and found that the company GTM is duly registered, right, on a number, MO whatever, right? But there were some formalities that were not satisfied. For example, right? Formalities that are required when what? When incorporating a company. So Adaona zimenezo awanangana a loophole of saying because of these informalities, right? They can say this company is not duly a company, right? It's an illegal company. So it means that it cannot sue UBC if they terminate what their contract. So they're asking us to advise. So as us, we have to use principles to advise this person, right? The most important thing is to advise. Right. So looking at the principle that we can come up here is the conclusiveness, right? Conclusiveness of full certificate of incorporation. That's basically the principle that we're supposed to highlight here. Right? So that's conclusiveness of the certificate of incorporation. So we could explain on this matter, right? According to the situation. So we could say that GTM was duly registered and awarded a incorporation number and certificate of incorporation. Right? Let me just say they awarded a certificate, although they did not say it, but because they gave him a number, means that they were added them a certificate of incorporation. Certificate of incorporation. This is enough evidence to conclude that all requirements were met. Right? Although UBC has identified some irregularities or formality issues, right? Irregularities, right? Right? Cannot, right? Cannot not conclude that cannot what dispute the validity. Let me just put it. Cannot dispute the validity of GTM company or limited. They cannot do that because of that, right? So it's still there. So advice is that they will find another way because the validity will still stand, right? Still stand, although these irregularities, right? You can just say that GTM can just go and correct these irregularities. It won't affect its validity as a company. So what we're saying is that GTM was duly registered and was awarded a certificate of incorporation, right? How do we know that? Because he was given this registration number, right? This is enough evidence to conclude that all requirements were met, right, or complied with. Although UBS has identified some irregularities, cannot dispute the validity of GTM company, right? The advice is that they'll have to find another way, right? Because the validity will still stand, right? The validity of the company will still stand, although there are these irregularities, right? What GTM can do is just to go and correct these formality irregularities. That's basically it. That's how you can advise that one. Now let us look at the last question, which is advise Mr. Brown on the recoverability of the loan in the circumstance. So let's look at the validity of advise Mr. Brown on the recoverability of the loan in the circumstance. Right? So saying Mnangagwa Jerry, acting as a promoter for prospective fruit juice company to be known as Golden Canna Company Limited, borrowed 10 million from Horizon Investment Bank Limited in March 2014. The loan agreement explicitly stipulated that Mnangagwa was contracting the loan as an agent of group of investors of the proposed company. The conviction of the bank was that the incorporation of the company was underway. In fact, on a number of occasions, Mnangagwa had shown Mr. Brown, the bank manager, a number of legal documents to that effect. The loan was repayable by April 2016, the bank having been convinced that by then the company would have been incorporated and be in a position to effect the repayment. But contrary to the expectation, Golden Canna Limited is yet to be incorporated, and consequently no single installment has been paid on the loan to date. Mr. Brown is now under intense pressure from the head office. All right, the head office, Durban, South Africa, will have the loan recovered immediately. So they're saying that what is the recoverability of this? So we're seeing the scenario, right? Mnangagwa is the promoter of the company yet to be formed, Golden Cannas. So Mnangagwa, right, yet to form, is a promoter of Golden Cannas. Mnangagwa went to the bank, borrow money, right? Convince them that he is actually acting as an agent of the investors of the yet to be formed company. Right? The manager, who is Mr. Brown, is now what? Is convinced because of some things, right? That Mr. Jerry actually brought in like illegal documents, right? So he thought by the time that the amount of money was supposed to be paid, the company will have been incorporated. So they borrowed an amount worth 10 million. But till now, right, the company has not yet been formed. So we should use a number of principles there, so that we talk about that. So we can talk about cases, and we can talk about a number of cases, and we can talk about the principles there. The principles there those are pre-incorporation, right? In pre-incorporation contracts, right? So you could just say that this is an example of a pre-incorporation contract. Pre-incorporation contract. Right. A pre-incorporation contract. Right? A pre-incorporation contract. So Jelly, right, cannot act as an agent of a company that is not yet formed. It means Mr. Brown can recover the money from Mr. Jerry, even though the company is not incorporated yet. So it means that the one that is responsible is what? Is this one, right? A case that you can throw in here. This is how you throw in a case. You just say, like in the case of, right, NARIFAM and Colomani versus National Seed Corp. Because it was sort of similar, right? Colomani was the one that was supposed to sue, right? In this same thing, right? Jerry is the one that is supposed to be sued, the promoter, and not the company that has not yet been formed, or a company that is formed but has not adopted yet. So that's basically your advice there, right? Your advice is say that you can recover it from Jerry, right? Because Jerry cannot act as an agent for a company that is not yet formed, right? Right? Like in the company, and he's personally liable, like in the case of NARIFAM and Coloman versus National Seed Corp. That's how you throw in the case. The case is not supposed to be explained, right? The only time you have to explain the case is where they actually ask you to explain the case. Either they might ask you that explain the cases, right? Or what are the relevance of the case. So you can explain and basically what? And basically explain and talk about the judgment. But for any other question, you just have to throw in a case like that. Like in the case of NARIFAM, this only time you can be allowed to throw in, describe the case is when you forgot the case, but you remember some of the facts, right? You can just say that there was a company, right? And there was a promoter that bought seed from another company, but know that it's still worth ngati munthu wina adakangolemba kuti like in the case of Nalifam versus, right? So it's better for you to memorize these cases and know where to throw them, right? Know where to throw them. Not just throw cases everywhere, but throw cases that are basically related to whatever you are discussing. That's basically the end of the chapter. I hope you have grabbed the concepts here, incorporations, promoters, formation, and so on. Thank you.